Okay, we're going to go ahead and get rolling again here on the transgender student hypothetical. And we've got an hour left to get through a lot of stuff, so we're going to move fairly quickly here. But this one is oh, I'm sorry, we got a question.
We got a few questions here. How do you protect a coach from the accusation that he looked at me when I was getting in the shower?
So Karen is going to, never mind. She's going to, nope, okay. So I will tell you this, it frustrates all of us, Karen more so, because she's right when she says for 10 years she's been saying that is a cop-out. It's not that we don't understand the concept that you're going to be called a creeper, and there may even be somebody that posts on social media that the coach stared at me while I was in the shower. We get all of that. Here's what we're going to tell you, is that you are listening to lawyers in a Title IX presentation who also have the, I guess, luxury of sitting in Lincoln and thinking about things like liability. The short answer is you should tell your parents at the beginning of the year that in Nebraska alone, we've had drumsticks, broom handles, and pop bottles used to sodomize students allegedly in school buildings or even outside of school. But as you know now, it's a Title IX issue. So you tell parents, if this is going to talk to your kid about it, if it's going to make them uncomfortable, they're welcome not to shower here at the school. Now, a lot of kids don't shower anyway now, but to the extent even that they have to change, I think you just be honest and own it. We, as the school, are going to have somebody in that room. That person is generally going to be there supervising. They may have to look at the students from time to time to do proper supervision. That is how it's going to be. So I think then you tell your coaching staff, hey, if they're in that same presentation with parents, this is how it's going to be here. It may be a change from the past, but I do not think you can handle it any other way. I get it. I get the not wanting to look like the creeper. Kids are going to say bad and inappropriate stuff. But the fact of the matter is most courts say that school staff members, as it relates to harassment by students, need to get a thicker skin, and you have to supervise locker rooms. We can't change those things no matter how much we understand your position.
Sort of joking, sort of not. Are your chances of getting sued greater under Title IX or Section 504?
Oh, man. Are your chances of getting sued under Title IX or 504 greater? I think your chances of getting an actual federal court lawsuit are greater under 504. And I say that because I think your chances of getting an OCR complaint are greater under Title IX. That's because any attorney who practices in the area of education law typically knows that the standard of deliberate indifference, that when the courts look at what it means for a school to be deliberately indifferent, like the case from New Mexico that Karen talked about, right? Judges, typically speaking, and the reason we see that standard articulated into these new regulations is that courts have been much less likely to find schools out of compliance or liable than OCR, because OCR is much more aggressive with its standard under Title IX. So I think you're more likely to get sued under 504 because, especially under the new Fry case, where you have to answer those questions about when it is a 504 issue versus an IDEA issue, for example, it's become clearer when a lawsuit can be sustained under 504 as compared to Title IX, where courts have generally been more deferential to the school as long as they can prove that they at least weren't deliberately indifferent. The legal standard to meet in Title IX is much higher than in 504, so I think that's probably true.
One last question on supervision. I have told my female assistant coach to just go in and make an appearance periodically until the locker room is cleared. Is that good enough?
I do not think that if you get sued because somebody gets harassed in there, that's going to be good enough, because going in and out implies that you know that you can have somebody in that locker room, right? If somebody just does spot checks or drop-ins, it's not that you don't have somebody in there, it's that you're saying they're not going to be in there all the time. Under a negligence theory, right, the question is, did you act reasonably? Was it reasonable to leave students unsupervised for blocks of time in a locker room? If you're sending somebody in to do spot checks, you're probably conceding that may not be reasonable on its face. So I don't like it necessarily. I understand where you're coming from. But yes, I think you're probably going to have to ask that person to be in there at least more often.
Before you answer this, because you can tie this in, what about bathrooms during passing periods?
So would you tell a classroom teacher, just leave the kids unsupervised? As long as you drop in once or twice in the hour, they'll be fine. You'd fire that teacher. So remember that the locker room is an extension of your program. It's just like a classroom. Now, bathroom during passing period, I think the expectation is for administrator or for teachers to be in the hallway during passing periods. You see who goes in there and who comes out. Students are not getting undressed and showering in the bathroom. They should be voiding and then coming out. And so I think that is a different supervisory issue because you've only got 3 minutes to pee and get out and get to your next class.
That's one of the things that people say to answer this question of, well, we don't want to pay a bunch of people to supervise the locker room all the time. Well, then you have to do other things in combination with more supervision, like limiting the amount of time, right? Okay, you got 4 minutes to get in and get out of this locker room right now. I'm locking the door 4 minutes from now. It's that idle dilly-dally time that we don't like, we just drop in on occasion, and that gives them the opportunity to do things that are violations of law or student code of conduct. So anyway, okay. Now on to the transgender student exam. So if you haven't figured it out, we have pretty strong feelings about locker room supervision. And so if you want the curse-laden version, call Karen. All right, so you are the assistant principal. Pat is a student who is biologically male, birth certificate at birth was male, but presents as a female, as a transgender female. A group of parents is threatening to sue you if you allow Pat to change in the female locker room, use the female facilities, claiming that, hold on a second, that would be sex harassment against my student that is not transgender, that's using the facility specifically designated for his or her biological sex. This, again, is not that hypothetical. We have cases like this coming up all the time in Nebraska. We told you 5 years ago, it's a matter of it's a matter of when and not if, and that's, I think, coming to fruition. But let's assume we're working on these facts. First, the Trump administration action Trump administration action on prior transgender guidance has kept the issue in the news because the Obama administration guidance that came out in May of 2016 said defer to, and that is a protected class. The Trump administration rescinded that, but didn't do a whole lot to make clear what the law was moving forward. So we'll talk about kind of what they have said since that. Anecdotally, like we talked about, more Nebraska schools are calling with these questions. It'd be interesting to do a survey to see now how many schools in Nebraska, as compared to not, have had a student notify them that they're consider themselves transgender. So the Office of Civil Rights and the Department of Justice issued that guidance we talked about. And then in 2017, the same time Trump administration was making the declarations with respect to Title IX generally, they are saying stuff like, well, that guidance letter essentially was the regulation by letter concept that we don't like. So they put out, in a non-ironic way, they put out a letter to withdraw the letter and said that essentially continued protection of all students is required. So we're not going to specifically target LGBTQ plus students or transgender students. We're going to say you've got an anti-harassment obligation for any student, which would apply if they're being bullied or targeted on the basis of their gender identity. And so they had internal guidance then that was leaked, so to speak, that came out, that was public. I don't think it was a mistake that it was more or less made public, where essentially I think they backed off even further this notion of this student says that their Title IX rights are violated because they can't use the bathroom or locker room as a transgender student consistent with that gender identity. I think internally they sort of looked like they were positioning off of investigating more of those independently. This is while lawsuits were continuing to trickle in with respect to the rights of transgender students under Title IX. So we'll get to that. So what they said is sex discrimination against transgender students will still be something that they may open an investigation on. So it's not that they're saying transgender students have no protections. It's just that they're not going to take the position that the Obama administration had with respect to when they might open an investigation. Sex discrimination, sex harassment for transgender students is all still going to apply. And the same with this concept of hostile environment, a hostile educational environment, it's called in some of these claims. But essentially where they say, if it's based on sex or the sort of sex stereotypes that Karen was talking about in her example earlier, such as refusing to use a transgender student's preferred pronoun when you call Robert Bobby, or when you call Steven Steve. If I say, no, I'm Bobby, you're going to call me he. So all of this notion about if a school gets what seems like a reasonable request that they make for a cis normative for a student that is not transgender, you can't fail to make that same accommodation for a transgender student. So they started, I think, frankly, to look at it kind of how we were viewing it under the context of you should make accommodations when you'd otherwise make them for any student. And so I think they kind of took that position in their internal investigation guidance. And again, retaliation against transgender student, all that stuff would still apply. So what they didn't say in the guidance is we're going to launch investigations purely on the school denied my ability to use the locker room and bathroom consistent with my gender identity. At the same time, the courts were coming down the opposite way, which we'll talk about in a second. So this is how OCR tries to parse through it, at least a couple of years ago in June, that it is entirely possible that if there's a whole laundry list of allegations from a student who identifies as transgender, some of those we will investigate and some of them we may not, even to the extent that our administration disagrees with the Obama administration on the application of Title IX to transgender students. So this is not a, hold on, we're not investigating any of these anymore, but we're going to parse it out on a case-by-case basis. And then according to news reports, OCR has essentially closed a lot of these complaints that were focused solely on the issue of facility use. So OCR and DOJ, again, they withdrew that guidance in cases related to Title IX. The Department of Justice argued under the Trump administration, in fact, that sex does not include gender. So this was in the Title VII context, which is the employment sex discrimination law. That's where Title IX gets a lot of its guidance from as courts interpret it. So you have the Trump administration really following through, though, on this sort of step-by-step notion to back away from the concept that the term sex encompasses gender identity. The New York Times even reported, and we talked about this, I think we all probably tweeted about it, I don't think we posted, but there's an article that came out that said they were floating a memo internally between the White House and the DOJ and the Department of Education of actually coming out with a new reg, like the green ones we've been talking about, which says sex does not include gender identity. For political reasons, for whatever reasons they may be, they have not done that. But I don't think it was a mistake that they floated that memo was circulating. So it's some combination of we're kind of still in the feeling out phase, but we're really kind of moving away from this notion that we're conceding that Title IX includes gender identity. And again, putting us sort of in the state of flux that we were before the Obama administration guidance.
That is a classic election year press release. I don't think that's gone away. I think they're just holding their fire.
Karen's probably right. She knows, if you couldn't hear, she knows that may be a political decision that they've made. Maybe they're now next year as the election heats up, they're going to start to roll out a little more of the roll back concept.
Who do you want, Elizabeth Warren or gender normative Donald Trump? I think that's what's going to happen.
Yeah. So one thing we did want to point out is that all that OCR guidance and the national, I guess, attorneys and people that were talking about this saying, you should allow transgender students to do whatever they want, use the facility consistent with their gender identity and not think again about it. The Office of Civil Rights actually launched an investigation into a school that had followed the very guidance that that office had issued on the basis that allowing the transgender student without restriction to use the bathroom consistent with their gender identity may have created a hostile environment in and of itself. So that's the reason we say in the OCR is officially drunk, because they said in May of 2016, allow that transgender student to do whatever it is that they identify with and don't ask questions about it. Then after the rollbacks, the same OCR launched an investigation when there was a sexual assault in the bathroom by that transgender student. So back to our fact scenario, the parents that say, I'm worried about my kid in the bathroom with that student, this is like the nightmare scenario where that happened in this school. So OCR says, maybe you shouldn't have followed our advice 2 years ago and put that policy in place. So again, the inconsistencies continue to abound. It's an evolving area of the law. So where do we stand now? The recently proposed Title IX regulations, the stuff in green that we've been talking about, does not redefine sex. So the notion of whether sex as a term, as an umbrella term, encompasses or includes gender identity still has not been clarified, at least in regulations. Some of the guidance remains in place, the stuff that we talked about before this. They have had on a policy level, on a internal investigation and handling level. There's no doubt the Trump administration has moved away from some of those Obama positions. And again, we still have no definitive for schools in Nebraska legal determination on whether Title IX covers a student who is transgender. So we're going to talk briefly here about the various cases under transgender. I think Steve is up first. Okay, real quickly, general litigation trends. If you take nothing away, if you've been like, all right, you just frustrated me again, fair enough. Number one, transgender students are winning their lawsuits on both the Title IX and an Equal Protection Clause basis, which we'll talk about in the cases. Number two, opponents, this group of community members that says, we're going to sue you if you allow the transgender student to use that bathroom, are losing their Title IX, Equal Protection, and invasion of privacy lawsuits.
All right, before we get into those, couple of questions. Does the Title IX coordinator have to be a certified staff member, or can it be a classified staff member?
I don't think it has to be a certified staff member. The interplay between discipline and Title IX is going to require some certification type of questions. But in terms of the ability, I think under the Student Discipline Act right now, you could designate investigation requirements to somebody who doesn't hold a certificate. But when those areas of state law require accommodations, things like that, to be handled by a certificate holder, it's going to matter.
If you go up to the top of the deck where we have what the Title IX coordinator has to, like what their qualifications are, they have to have the ability to like speak into policy, to have supervision, to influence the programs. So I think like a high level business manager, but I don't think they have to be certificated, but I don't think it can be your para. I think they have to be higher up than that.
In regards to supervision, how would you handle an away game with an all-male coaching staff?
Get a parent volunteer.
Yep.
And have that lined up ahead of time.
Yep.
Have all the other parents informed that that's what's going to happen. Tell those parents they're welcome to take their kid with them if they don't like that. I'm going to say this, and I love you all. Stop looking for excuses. There are ways to do this that I think you can do lawfully, and it's about informing parents of how it's going to go.
We find a way to get the fucking picture of the seniors transported to away games so we can put that up with zip ties on the fence, because the parent group gets themselves organized to do that. If you truly don't have a female to supervise, have a sign-up sheet for the parents for every away game. Hey, you have parents provide meals on the way home. You provide meals for film study. This is just, if you're going to use parents, I think that's perfectly fine. You just add it to the list of things that you're asking parents to volunteer to do.
Have them comply with your volunteering policies. Make it a requirement. Again, to me, the whole thing is making sure everybody knows up front this is what you're going to do, so you avoid these questions of not looking creepy. Who do we have doing it for an all-male staff? Those are practical problems, not legal excuses.
Back to transgender. A transgender student, biologically a boy, appears as a female, wants to be referred to as a female name when announced at graduation. And graduation gowns are blue for boys and gold for girls. What to do?
Make all your graduation gowns one color.
Yes.
If you are willing to call Robert Bobby as I walk across the stage, I worry that even the Trump OCR would say you should call Jane John if that is how John as a transgender male asks to be identified. How do you distinguish between being willing to, in every document you have and every decision you make, call Robert Bobby, but say, and there are actually cases where teachers have been fired and have unsuccessfully sued because they have failed to accommodate things as simple as names and pronouns. So if I'm your staff, if you're talking to your staff, you should point to some of those cases where those staff members have said, I don't believe in that, or it violates my religion, or it violates my something, and say, well, hey, there are teachers that have literally been fired and sanctioned by their state departments of education for not complying with these directives.
For your graduation ceremony, I know what you do. You all say to the kid, tell us what you want called when you go across the stage. My kids have two middle names. It's Anna Marie Hasse Weber. My kids both had to tell them whether they wanted the Hasse in there or not. And I wasn't offended. It was but because the onus was on the kid, right? Kid, you tell us what you want called. Since you do that with typically gendered students, I agree with Bobby. I think you have to do that with transgendered students. Now, if you're telling me that you literally have your bookkeeper pull the birth certificate for every single kid, and you read what's on the birth certificate, whether they like it or not, then you can call the transgendered kid Francis instead of Francine. But unless you do that for every single other kid, you're gonna have to go with what the family requests.
I think that's right. And here's the problem. If you polled the students, almost all of them, I bet, would say call him, call her, whatever they want. You're trying to avoid a parent community perception issue, which I understand. For the most part, it's not students who are raising these things, right? I mean, that's just the truth. So, yeah.
All right, athletic director, activities director is a Title IX coordinator, okay.
Yeah, I think so.
Yeah.
Yep. Again, the only, I think, interesting questions will be when it comes to the discipline part, what certificate does that person hold?
The AED assistant principal, we have to think about how that works, but I think it could work.
Yep.
If the student is 13 and their parent doesn't want them to be called their transgender name, as the student is requested, what do we do?
The Office of Civil Rights out of Kansas City still has sort of a parent deference approach. The Office of Civil Rights out of Chicago says you ignore the parent request in favor of the student. We have no idea what the law is going to shake out on that issue, other than knowing, think about how it would happen. If I came into you crying and said, listen, I hate the name Robert, I want to be, please call me Bobby. And my parents said, you will call him Robert when he's here, what would you do? Because I think the answer is you should do the same thing. At least that's what OCR has told us.
And trust us here, we don't call them Bobby or Robert. So the Adams case, this is actually an interesting case because it's one that actually had a trial. It's one of the few. All the others didn't make it through a trial. They're decided on paperwork before they ever get there. So what we had here was a high school senior. It was a plaintiff who was biologically female, identified as a male. The school had a longstanding policy that required students to use their sex-segregated facilities in line with their biological sex. The interesting twist to this is, this was in Florida. If you change your gender through whatever means in Florida, you can go and get a new birth certificate that changes your gender on the birth certificate. So Adams had been in the school system since the beginning of time, and so he was registered as a female and was not allowed to change that. Once you put it in the system, you can't change it. Whereas if somebody who had changed their gender since birth but hadn't attended the school and then registered, well, then they had no problems recognizing that transgendered person. So it's kind of interesting how they would pick and choose how they were going to institute this. But anyway, this school actually did a fantastic job. They created these guidelines. They got this huge committee together. It had the school's attorney, it had teachers, parents, it had a whole bunch of people. And they went and visited other schools. They did a fantastic job of looking at how should we do this? What is the best way to do it? What is the legal way to do it? And so they created these guidelines to give access to these gender-neutral facilities. Students were not permitted access to boys' bathrooms, but was not required to use the girls' bathroom. In essence, they said, we've got these unisex bathrooms, so you can use the girls' restroom or you can use the unisex bathroom, but you're not going to the boys' bathroom. That's basically where they put the law down. It was interesting in the sense that in every other way you can imagine, they accommodated this kid. It just came down to the bathroom. They didn't have a locker room issue because Adams had no need to go in the locker room for any reason. But for all purposes other than the bathrooms, we didn't have an issue. They accommodated Adams. So they filed a civil rights lawsuit saying, hey, you violated the Equal Protection Clause and Title IX. Again, it went to trial. They had a 3-day trial in front of the judge. That was fascinating. If you're going to read one of these cases, I'd read this one. It's about 25 pages. They have all the psychological information at the beginning that really spells out all these terms and does a good job from a psychological perspective, saying this is where the issue is in the psychology world. So anyway, the bathroom policy, according to the court, was a sex-based classification subject to intermediate scrutiny. Won't bore you to death, but there's strict scrutiny, intermediate scrutiny, and then kind of a rational basis test. It's real low. So we're in the middle here. And so under this approach, they have to show its gender classification is substantially related to a sufficiently important government interest with an exceedingly persuasive justification. You can see that's kind of a high barrier the school has to meet. That's not too simple. And the school says, oh, we got it. We got concerns for safety and privacy, and those would withstand your intermediate scrutiny. And the court said, nah, we don't think so. And they said, well, what about their privacy? And they said, well, wait a minute. The evidence shows that, and this is why it was important they actually had a trial. Adams testified, when I go into the bathroom, I go into a stall, I close the door, I do my business, I come on out, I wash my hands, I leave. That's it. Nobody sees anything, and I don't see them. And so they said this privacy thing doesn't sell. And they said, besides, you've got gender normative kids, you've got cisgender kids, you've got gay kids. If they want to peek in the bathroom, they can peek. This isn't holding any water, so they weren't buying the privacy argument. So they turned to these Title IX claims, and they said you have to show it's discrimination in the educational program. Discrimination was on the basis of sex. The school board receives federal funding, and the discrimination caused the plaintiff harm. Really, we're looking at that second prong there. Was the discrimination on the basis of sex? And that's what all this litigation really is about, is just the term sex, whether it's Title IX, Title VII, or any of the other laws. When they say sex, does that include gender identity or any of these other related categories? So the issue is whether its exclusion was on the basis of sex. They said Title IX does not define sex. Neither does anything else for that matter. Noted that the OCR guidance had been rescinded. That was the guidance. One day they were saying, hey, it doesn't include it. Then they're saying, yes, it does. Then they repeal that, and now we're back to, well, we don't know where we are. So we turned to Title VII precedent, and they did find that sex included gender identity. And they look at gender norms. People have been discriminated against because they were female, but they presented more as male. And so they said, yeah, that is in an employment context protected by Title VII. This judge looked at those laws and those cases and said, yeah, we're going to find for Adams on the same basis. They gave him attorney fees. I tried to find out just to give you guys an idea of what kind of dollars we're talking, but I'm thinking given the amount of prep they did in a 3-day trial, it was a good number. Only $1,000 in damages, but you only need $1 so that you can get your attorney fees. And they gave him an injunction allowing access to the boys' restroom. This was not an overriding injunction that applied to everybody. They limited it only to Adams because that was the only evidence that was presented to the judge. Bobby? Oh,
I'm up. So this is the case out of Wisconsin, Whitaker versus Kenosha. If you've been a part of any Title IX discussion on transgender before, you've probably talked about this case since 2017. But this is a student who I was female at birth, transitioned in 8th grade through their junior year when the lawsuit is filed to being representing as male. Had some really interesting related health issues, which I think makes this case seem a lot clearer when you just look at the holding of it. But I think this stuff is important. So this was a condition that essentially rendered the student capable of fainting if he was dehydrated. So one of the solutions, and so he was eventually diagnosed with gender dysphoria because the marked incongruence between his biological sex and his represented gender, began hormone therapy, actually went through all the process to change his name and all of that between 8th grade and junior year. The school had a position that he could not use the bathroom consistent with his gender identity, so he stopped drinking water. Now, I'm not saying it was a part of the litigation strategy, but if he got dehydrated, he would pass out. So it became necessary by doctor's order for him to both drink more water and use the restroom more regularly. So I think it forced the issue whether he intended it or not. So for his junior year, he just decides, I'm going to start using the boys' bathroom, and that actually happens for 6 months. A teacher eventually reports it to the principal, who meets with the kid, who says, hey, you can't use the boys' bathroom, you need to use the girls' bathroom, because on your birth certificate still it says that you are a girl. So the school directed Ash to use either the gender-neutral bathroom or the girls' bathroom, which again, strangely, OCR has accepted that as a solution in some of these cases, but the court in this case very specifically says, no, that's not good enough. So despite the school's directive, the student continues using the boys' bathroom uninterrupted for the remainder of the year, which begged the question to the court of how seriously they actually felt about the policy. And it could be, I'm reading the tea leaves here a little bit, but it could be that the school board and felt pressure maybe to put a policy in place that said do X, Y, or Z. And the administrators thought, well, if we enforce it that way, we're going to get sued. So I don't know exactly what happened, but either way, he uses the bathroom. But because he's repeatedly told, you shouldn't do that, he develops suicidal ideations and eventually files a lawsuit under Title IX and the Equal Protection Clause in the Constitution, which says essentially that you must treat similarly situated people the right way. And that becomes significant as we think about like the graduation issue, the name, pronoun issue, because it stops looking necessarily at whether Title IX includes gender identity and looks at whether similarly situated people are treated the same way. So he says, number one, you denied access to your facilities. Number two, you didn't use the pronoun and name that I asked you to use. Number three, you required a separate bathroom for me, and including separate bathrooms and rooms on trips if we took field trips. There was an allegation in the case, which unfortunately was not documented very well by the school, that the administrators had at some point considered requiring any transgender student to wear a bright green wristband so they could track where they were going to the bathroom more regularly. And they didn't allow him to run for prom king. So those are the things that Whitaker alleges in the case. So the opinion says, basically, Ash is a 17-year-old that made a simple request to use the boys' restroom while at school. And so then when that's how the opinion starts, you know how it's going to shake out. So the Seventh Circuit says, hey, to the extent that that lower court allowed Ash to use the bathroom that he wanted for his senior year, we completely agree. A policy that requires an individual to use a bathroom that does not conform to his or her gender identity at the time they ask or make the request violates Title IX and the Equal Protection Clause. Now, the Seventh Circuit does not apply to Nebraska. We still do not yet have a case from the Eighth Circuit stating this as clearly. But understand, the Seventh Circuit, Sixth Circuit, Third Circuit, Fourth Circuit, the case that Steve was talking about out of Florida, they're all going the way of upholding the students' claims with respect to Title IX and equal protection and transgender. So they sent the case back down and said, yep, student, I think unless school you have any better arguments, you're going to use the bathroom that you want. In January, they got to this issue of attorney's fees that Steve was talking about. There was an $800,000 settlement paid probably by some combination of the school and the school's insurance carrier. The student got $150,000, the student's lawyer, $650,000 in attorney's fees. That's a lot of money, and that is obviously not something, I mean, they only really got to the phase of the student arguing that I should get to use the bathroom. They didn't go to what we call summary judgment. They didn't go to a trial. That's just to get the court or get the case in front of a judge to answer the question of, should the school be stopped from enforcing this policy? Should we allow Ash to use the bathroom that he wants? That alone was an $800,000 settlement. The student's attorney was interviewed and in a news report said, this should send a clear message to all school districts that discriminating against transgender students is against the law. So again, it's a matter of time. We'll have a case in the 8th Circuit. So far, we don't, but the cases by and large are going that way.
All right, we're going to talk about a case out of Indiana, JAW. What we had here, this was very similar to the Adams case that I just talked about, but this was a preliminary injunction case. I brought my paper because I wanted to quote the court. You tell me how this turned out. At the hearings, he looked and sounded like a teenage boy. He is very unlikely to be mistaken for a girl at this point. Uh-oh. School's in trouble. And so what we had here is a biological girl identifying as a boy, started using the boys' restroom without asking or telling during the PE period. Parents, it wasn't the kids that were upset, which is often the case in many of these instances. Parents of 2 boys complained of the girls using the boys' restroom. The school told the students not to use the boys' restroom, provided access to a separate room, which actually was an unused girls' locker room. So they were, obviously, the JAW was rather offended by that. JAW attended classes in 2 buildings. They said, use the girls' restrooms or use the nurse's office, which had the unisex bathroom. They were required to obtain permission to go to the nurse's bathroom. A lot of times when they went there, it was locked. And you see this, this is a theme throughout all these cases. They stop drinking. They don't want to take any liquids in because they're afraid to go to the bathroom. It's embarrassing. Either my choice is I have to go to this unisex bathroom and everybody knows why I'm going there, or I have to use the wrong bathroom. And so they're not too excited about that. So they relied on Whitaker, and the council sent her attorney or the boys' attorney sent a request to the school. Says, hey, let him use the boys' restroom. You better read this Whitaker case. And the school said, yeah, now that case is totally different. Doesn't apply to us. So JAW sued, went for an injunction. The court applied Whitaker, found that JAW was likely to win both on Title IX and the equal protection claims. Rejected the school's argument that the circumstances were distinguishable. They said, no, it's pretty much the same case. That's not going to fly.
So the next case, so you can see how these are going, right? That's a series of cases where the transgender student and their family win their lawsuit. So you've got Whitaker, you've got JAW, you've got the Adams case. There are several others. A string cite at this point would be very long. This is a case where a group of families in one of these circuits that has decided a case in favor of the transgender family made all the same arguments on the opposite side. So you have the students who are cisgender, the students that are, their gender identifies consistent with their biological sex. The boys saying to the school, we want to use the boys' restroom facility locker rooms without any biological females in there. So in other words, your policy of allowing transgender students to use the facilities consistent with their gender identity discriminates against us, the boys that want to use that facility without them in there. So initially, the court goes through and does a thorough analysis of basically what they say is, it is not possible to understand these cases until you first understand the definitions. And so the court, again, one of these cases, you know exactly how they're going to go. They start referring to the typically developing non-transgender boys as cisgender, which is the term that's kind of been assigned to somebody whose gender is consistent with their biological sex. So the court throughout says this group of cisgender high school students brings a lawsuit to ask us not to allow their classmate who is transgender to use the same facility. And the long and short of it is, they tried all the same arguments and tactics. They stopped drinking water, saying that we don't want to use the facility. They said it stigmatizes against us to have to go to the nurse's bathroom when you don't require the transgender student to do that. So they literally use Title IX, equal protection, invasion of privacy, all these rights that courts are using to say the transgender student wins. They're making those arguments on the opposite side, using the same, setting up the same facts as we just talked about in Whitaker, Adams, and JAW. So the district court in this case, the lower court says, nah, I'm sorry, students, you don't win. It goes up to the Third Circuit who says, yeah, as to your constitutional right of privacy, sorry, we don't buy it. The school is justified in invading anybody's privacy as long as they're proving that their basis for doing it is to avoid discrimination. So if the school is going to get sued by the transgender student, they can force you into that discomfort. I don't care how it makes you feel, if their purpose is to avoid discrimination, which again, based on those cases, is what they were doing. As to your claims that your Title IX rights should be protected, the students failed to show any hostile environment. That biologically female transgender male student using the bathroom or locker room with you, you've failed to provide any proof other than your discomfort as to how that's created some sort of hostile environment. So if you have not been discriminated against on the basis of your sex, then it's not something that this court can support. So basically the bottom line is the students and their parents who tried to use the exact same facts and the exact same arguments to the exact same court end up losing, which isn't a surprise. But we hear this question all the time from boards and administrators in Nebraska. What about the constituents in our community that say, I'm not sending my kid into that facility with that transgender student? And the short answer is, if the Eighth Circuit goes like all the other circuits that have decided the issue, tough. They're not going to win their argument. And if your reason for allowing the transgender student in is to avoid a discrimination claim from that person, then I think you've got the right to do that. Now, you should still handle all these, we think, on a case-by-case basis. You'll see that in a lot of these cases, the schools that get sued are the ones that make a definitive policy statement one way or another. I get the instinct to do that, but our position has been from the beginning that if these are truly Title IX claims, then they're by definition individualized. We shouldn't have you don't have a one-size-fits-all response for sexual assault victims. You shouldn't have one for all transgender students.
Run that analysis for the gay locker room.
Oh, okay. So Karen says, run the analysis for the student who says, or the students that say, I don't want to share a locker room facility with a gay student. So this is not a transgender student, right? These are all biologically male or female students, but one of their students says, I am gay. And so this notion of that person in my class who is also a male and I'm a male, it makes me uncomfortable because I know he is attracted to males, I think falls on the same sort of deaf ears in these courts. The fact of the matter is, if that person is walking up and saying sexually explicit things to his or her male classmates as the gay student, or if they're doing things to purposefully make them uncomfortable, then you should address the misconduct, not the sexual orientation status. That's what OCR says time and time again. If misconduct occurs, I don't care what the students identify as. If there's bullying, I don't care if it's on the basis of gender identity, weight, hair color, attractiveness, you're going to address it because it's bullying. It's the fact that we think we should have fundamentally different rules for gender identity and sexual orientation that typically gets schools in trouble.
All right, this poor school district in Illinois couldn't win for losing. This school district first gets an OCR filing against them by the transgender student saying, hey, you're not letting us use our bathrooms. And it's just like the other cases. They're putting them in the unisex bathrooms, or they're making them use the bathrooms of their biological sex. And so this school district settles with the transgender students and their parents, and they come to a resolution agreement with OCR. And it allows the transgender kids to use the facilities in conformance with their gender identity. So all is well, right? This is how all the other cases have gone. That's what we're doing. Well, no, of course not, because now the other parents jump in and say, parents of the cis gender kids, and say, hey, wait a minute, what about our rights? You're violating our privacy. All the things Bobby just talked about, the privacy, we're embarrassed and humiliated to have to address with these people, and yada, yada, all those things. And so they sue and say, you're violating our Title IX rights by making us hang out with the transgender students. And the district court said, no, there's federal protections against sex discrimination. They're substantially broader than those based on only sex genitalia or chromosomes. The students will suffer no irreparable harm. And again, just like Bobby said in the previous case, any student who fears their privacy would be impaired by encountering a transgender student in the bathroom or locker room simply has to access existing and available single-user facilities. So you can see how in all these cases, if all you had was single-user facilities, nobody has a complaint. And that's why I think we're going to end up there.
Yeah. So practically speaking, I think we've hit on most of this, but to Steve's point, courts are recognizing this notion that, oh, we'll just ask the transgender student to use a single sex or a non-described sex facility, the nurse's bathroom, the teacher bathroom in the hallway. Courts are saying, well, why don't you just make all the typical developers that are uncomfortable that the non-transgender students do the same thing? So it's obviously a game of chess, right? And as these cases get through the courts, that you can see where they're starting to align, and I think how it's going to go. So we talked about this. I think the best strategy is still to avoid making any sort of sweeping policy or procedural decisions. When a student comes in that says, I am transgender or I'm transitioning gender, the conversation with them should be very much individualized to their needs and where they are. I wouldn't just say, okay, give me the pronoun, give me the name, what bathrooms are you requesting, right? Because that's not how it's supposed to work. If that student said, I'm a victim of sex assault, they could have fundamentally different requests. And then work collaboratively with those students on their specific needs, knowing that eventually it is true that we can't make the decision for you. We can't make it for the board. But for the most part, I think an administrator making an informed decision at the time is the best defense, even if that decision is wrong in the eyes of one side or the other, versus a board stepping in and making a policy decision. So that's still our advice of how to handle situations like that where you get the requests.
All right, Bobby. How would transgender students and rooming in hotels for school activities work? Keep in mind limited rooms and budgeting for an extra room.
Well, so the Office of Civil Rights would say, unless you've got some sort of particularized fear, you should allow the transgender student to room with whomever, consistent with their gender identity, right?
And then if the cisgender student objects, they pay for their own room.
Yeah, that's right. And so Karen's point was, and if you have an objection from the parents of how the school's going to handle it, you can always give them the ability to pay for their own room out of their own pocket. I worry about the whole suite of issues. I worry about whether that parent's going to say nope under the Student Fees Act or something like that. They're going to have a good argument that the school should just buy 2 rooms. I mean, I get the limited budget thing, but in every context we talk to you about, we have a limited budget. That's not in the budget. It's not an adequate response.
I don't think buying 2 rooms is going to work because remember the camping case where they put the.
Yeah, so Karen's right. I mean, this is what I'm saying. You can't win. There is no this is how to handle it, because in cases where students have been told, no, we'll just get 2 rooms. That student has said, well, you only got 2 rooms because you think I'm transgender and that person thinks I'm creepy. So you've stigmatized the transgender student by buying the separate room in the first place. Again, there is no right answer, which is frustrating. We wish there was. We pride ourselves in helping you get to the answer that you want if we can. But for the most part, the answer here is, what does that student want? I think if you ask the student who was set up to bunk with them, hey, are you cool bunking with Steve, the biological female that's transgender? We can work it out so that obviously you don't have to be in there when any of the showering's happening. I think those students, I think the students are actually probably more okay with it than you think. That again, that doesn't address the parent issue. But frankly, I'm not as worried about the parent issue as I am the reality of what you think is appropriate for that particular field trip.
Sports question. When a student identifies as a specific gender, does that require the individual to participate in sports for that gender only? In other words, no jumping back and forth. A girl that identifies as a boy wants to use the boys' restroom and do everything as a boy, has to play boys basketball and can't play girls basketball?
I believe that's what the NSAA's policy functionally says at this point. The lengths that one has to go through as a transgender student in Nebraska under the NSAA policy to be eligible to participate consistent with their gender identity. I don't know that, I'd have to go back and look at it. I don't know that it says once we agree that you are a transgender student who can participate, even if you're biologically male, as a female in female sports, because you've gone through our policy and what it requires. I don't know that it says that prevents you from going back and making a different decision later, but I think it implies that. And frankly, I don't know that somebody would go to the lengths that you need to satisfy that policy only to go back on it. So I think the short answer is, right, wrong, or indifferent with whatever the NSAA's policy says, you get to defer to that to some extent. The school is the one that helps students initiate that process, though. So if I was an administrator or an AD, I think my response would be, listen, the NSAA has a policy. We're not going to commit school resources to help you prove to them what you need to prove to them to be able to participate consistent with gender identity, but we'll certainly help you file that with them and start the process. Then it becomes an NSAA level decision. So I mean, that's how I would handle it. I don't know if that doesn't get to the root of it, shoot another text to Steve, but I think that's still the best response.
What is legally required to confirm a student is transgender? A doctor note or parent letter?
No. The fact of the matter is, unless you're talking about an actual gender dysphoria diagnosis or something like that, you're going to get a varied responses, even within the LGBTQ plus community, of what it means, what it takes. The school boards, the activity associations nationwide that have tried to say, all right, we need to see these 3 things, they're getting challenged on that. I think the short answer is, if you have a student who says, I'm transgender, Title IX says you meet with them and listen to their requests, no different than you would somebody else who says, I'm fearful that I'll be discriminated against.
Jason Dolliver said your response made sense, so he clearly didn't listen to anything you said. Are private schools held to Title IX regs? Yes, if they receive federal funds.
We do work with several private schools, and the question is always, we need to track every dollar in, dollar out, even the pass-through stuff down through the state to figure it out.
Do students who identify as J-skers have any protection from discrimination? As far
No,
as I know,
no. And in fact, they should be eliminated from the state, period, if you're a J-sker. Sorry, Brad.